I have a matter to take up in the case of State of Georgia versus James Avery. I'm going to take it up ex parte, and so I appreciate everybody. We are scheduled for a revocation hearing on Monday morning at 9 a.m.
And Your Honor, just to be clear on the matter with fall auto repair that was originally specially set for Thursday, but it's now being reset out to March.
Right. So. Yes. So we are not having a trial Thursday morning or Friday morning because it was set for both.
Correct.
That's great.
And Judge, if I may inquire about the James Avery matter, not about the ex parte motion, but just about scheduling. Would the court like the county, specifically the solicitor, to wait outside of the courtroom until the conclusion of today's inquiry by the court, just for the purpose of any scheduling matters to return? The only reason I ask that, Judge, is, as the court said, we have a revocation hearing for Dr. Avery scheduled for Monday morning. We also have community members and other witnesses who are planning on attending Monday morning. And again, Judge, the only reason I ask is not knowing what is within that motion, but knowing the title of the motion, Judge. I just want to get guidance from the court as quickly as possible.
Right, that's fine. Just in an abundance of caution, y'all can wait outside. When we're done with the motion, the hearing on the motion, the deputy will tell you, and you can come back in and I'll let you know whether there's any change in the schedule as set.
Thank you, Judge.
Thank y'all.
May I ask the question at this point?
Not yet.
Okay.
All right. So, we are on the record. It is being recorded. This is, for the record, this is the Magistrate Court of DeKalb County, Ordinance Division. This is the case of the State of Georgia versus James Avery, citation number 027588, 026200, 027593, 028660, 028314, 028311. And so, Ms. McGaughey has filed an ex parte motion withdrawn. She is present. Mr. Avery is present. Mr. Avery has the listening assistance device. Is it operational, Mr. Avery? Can you hear?
So far I can, as long as everybody's speaking to the mic.
Okay. All right. Yes, ma'am.
Yes, Your Honor. Your Honor, this is the case of Mr. Avery and McGaughey, currently representing Mr. Avery. I have filed an ex parte motion to withdraw based upon the complete breakdown of communications between myself and my client. I'd also like to preface, I think the last time I filed a motion to withdraw in a case was over 20 years ago, quite frankly. And that was for someone who I knew was going to commit perjury. So this is not something that I do lightly, and it is not something that I do frequently, to say the least. The court appointed Mr. Avery for us to represent Mr. Avery over a year ago. At that point in time, he had applied for the public defender's office, was told that he did not qualify. In reviewing the records, it appears at that point in time he had at least $50,000 in the bank and at least $350,000 in equity in his home. At that point in time, the court decided that they were going to appoint Mr. Avery over our objection because they were concerned about some mental health issues. And if I'm incorrect, please correct me.
No, you're correct.
We are here over a year later. It is still our position that Mr. Avery does not technically qualify for the public defender's office. It's my understanding that he is down to close to zero in cash. he still has at least $350,000 in equity in the house. He owns that house free and clear. He has the options to sell, he has the options to take mortgages. The fact that he chooses not to and has chosen not to is immaterial, quite frankly. When the court appointed us, it's my assumption that the court wanted us to assist Mr. Avery in presenting his case to the court and how he proceeded, and was concerned about the mental health issues. We have been concerned about the mental health issues. In fact, we filed a motion to have him evaluated. He has been evaluated. The evaluation came back competent. In speaking to Dr. Flanagan, it's my understanding the evaluation comes back competent because they are relying heavily on his representation that he has been using methamphetamines every day for several years now. And his symptoms, while they could be psychiatrically driven, can also be based upon his substance abuse. And when symptoms can be explained by substance abuse, the law is that someone is competent at that point in time because it's more of a voluntary issue than a mental health chemical imbalance. I have met with Mr. Avery on numerous occasions. And early on, I decided the way to communicate with Mr. Avery was in person, because everything that I sent him in email, everything that I sent him in letter is posted on his blog. There have been several occasions where Mr. Avery has come into my office, asked if he could record a conversation between us. I have said no. No, sir, you may not. If the court cares to look at his blog, you will find those there. And on those occasions, he has always abided by that. Now, I realize, according to Georgia law, that a conversation can be legally taped when one party to the conversation knows that it's being taped. So I am not saying that this is illegal. The last conversation that Mr. Avery and I had prior to the status conference, apparently he had recorded that. I did not know about this recording until we were leaving court and Mr. Avery said, by the way, the last conversation we had, I have recorded and posted it. And lo and behold, it is recorded and posted on YouTube. He apparently also recorded and posted the 2-hour competency evaluation that Peggy Flanagan did. I've been able to find that. He has put all of his medical records from when he was 10-13 on his website. And aside from the abusive nature that I believe the court did witness in court when we were in here, which, quite frankly, I don't need to be cussed out. I am asking to be withdrawn from this case. I do not think I add any value to this case. The conversations that Mr. Avery and I had go over trial strategy. How to defend against the revocation, which is what is before the court. I am not retrying the initial case. Mr. Avery has significantly different opinions on how that would proceed. Mr. Avery does everything to thwart my representation. Mr. Avery would like to be able to have a hearing, to have a discussion about his views on things. It is a platform for him to tell his story. I am not amused to be part of his story. I know he was very upset with me when I first started representing him because my internet presence is very minimal. And it is minimal on purpose. The only thing he could find was an old case and my public Facebook picture, which had my children, which went onto his blog. My Facebook picture has now the Callaway building when it was being torn down. And I had thought we had gotten past that. But at this point in time, I cannot communicate with Mr. Avery. Everything that I say to him is posted. So there really isn't any attorney-client privilege. And in addition to the complete breakdown of communication, I don't trust him to communicate to. And I do not know how I can effectively represent someone when I cannot communicate with them and do not trust any communications that I make with them. I don't know what else to say. I think I've laid it out.
I don't think,
All right, I'll hear from Mr. Avery. Mr. Avery?
sure, I got it.
Raise your right hand. You swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of perjury.
That's why we're here. That's all I've ever done.
Answer my question.
Yes.
Put your hand down. With respect to Ms. McGaughey's motion to withdraw, do you oppose the motion?
Hang on, this thing goes away with static. Okay. No, I mean, she really made no effort to hear what I was trying to say and represent me in the way I needed to be represented. She just, everything I said to her, she just dismissive of.
Well,
There's really no difference with her or without her.
well, if she doesn't represent you, do you intend to hire private counsel?
No, sir.
So you're going to represent yourself?
At this point in the game, I don't think it's possible.
You don't think what would be possible?
Representing me fairly.
Who's
This is-
representing you fairly?
It's just too much in details involved. I just don't think I can find anybody that will be willing to take on this case. I mean, like I told Whitney Gibb, this thing is really acting up. Static, a lot of static. Every time I talk, it stops. Where was I? Right after the trial, the first hearing that we had, I think it was January 31st, 2017, just before we came in, I'm asked if I wanted to appeal. That's the first time I've ever been asked for it. And I told Whitney Gibb, along with the female lawyer that was with her, I don't know his name, I can't even get his name, both of them, why I was not going to appeal. And I've written several emails to the public defender trying to get a hard copy answer of what it was that I told Whitney Gibb. And also, well, I want to know what Circuit Public Defender Claudia Febuary, how you pronounce her last name? I mean, she said there were excellent issues to appeal. And I have not been able to find out what those excellent issues to appeal. They have never encouraged me to appeal. And I already decided before I met with them after the trial that I wasn't going to appeal. But they never tried. And when I got asked for copies of my file with the public defender, there was an email. One from Claudia Febuary to my public defender at the time, Whitney Gibb, asking if I intended to appeal, and also she thought there were excellent issues to appeal, and I cannot find out what those issues to appeal are. And they have not been working with me, and basically, there's a tumor on my brain, pituitary gland, which needs to be worked up. I do not have health insurance. I just continue that on purpose. That's on no point, and continue to pay premiums on it if I had no hope for the future. And it's just too many details there. I just can't go into with a new lawyer. This is like the fourth one. Mary Maloney was out that felt like was listening to me, the very first one, but she got abruptly rotated out. And then Lauren Sedalia said that it was the intermediary until we had Whitney Gibb rotated in from elsewhere. And I asked her, why can't you be my lawyer? And she just kind of gave me that. And I go, remember now, I did not ask for you. You were assigned to me. And this is where that you do not conclude until understanding. What's understanding, you do not judge. And this is where your job is to conclude these hearings before understanding in a way that gives the appearance of justice having been served. And I've even said the day we waited on you being 2 hours late, I did not come here prepared for this. But the day we waited on you being 2 hours late, she comes up to me and goes, this thing you're wanting, a non-criminal fact-finding hearing justice. There's no mechanism for this. And I go, well, then that is our problem, isn't it? So never once had reconciliation been offered to me in any form, any way, shape, or form. And it's just getting bigger and more frustrating for me. May I just, at a moment of levity, may I tell a joke that might help play the next part? No? Okay. It has to do with lawyers representing me from this point on. No? Okay.
All right, so you don't oppose the motion to withdraw, but you have no intention of hiring private counsel.
No, because I don't think they'll be able to understand this amount of time. If they came to me pro bono and convinced me that they were willing to represent me, and I bought, and that showed me that they understand what I'm trying to do, then that would be a different story. But like I said last time, if this is considered to be an example of, I'm speaking from the perspective of Supreme Court Justice Scalia. He didn't think the Twinkie Fit would be an invention of a competent lawyer. When he has a lawyer, he wants to win. So if this is to be considered an example of a competent lawyer, then what should it be saying about the rest of the other lawyers, including the judges? So I know the judiciary system has a history of self-regulating themselves, and it just and I've repeatedly having trouble with a copy of the record. I have a copy with have a file with the Emory plea. They just now recently letting me have copies of them, but they didn't provide me with everything that was in there, like emails that were uploaded to the file from other people, like Reverend Dr. Beth. So I can refer to be introduced to God before I'm aware of God, as one of the first United Methodist Church of Prescott, Arkansas, population 4,000, helped raised by that church right up until I graduated from high school.
So I understand your position, Mr. Avery.
And it's a Methodist story.
So I don't really think I need to hear anything more at this time. So if you could just have a seat.
Sure.
Well, Mr. Avery, the DeKalb County Public Defender's Office is probably the best public defender's office in the state. I don't mean any offense to the other public defender's office, but I've known the DeKalb County Public Defender's Office and the people in it for many, many years, and they are some of the finest criminal defense lawyers in the state. And so I know that they will represent you well. And so I'm not at all concerned about the quality of their representation. I've known Mr. Boyd for many, many years, and she's an excellent lawyer. So I don't have any concern that they're representing you, zealously representing you to the best of their ability, and as well as any lawyer could. Ms. McGaughey, I'm sorry. I know that some clients are challenging, but I'm going to deny your motion. And we'll see y'all Monday morning. Thank you. All right, we can let the solicitor back in. The assistant solicitor, I'm sorry.
The question I had earlier, may I ask it?
The hearing's over.
Okay. There you go.
May I ask your grounds for the denial? May I ask your grounds for denial?
Okay, I just have a question for you. How soon will they have the recording over there from this today? Okay, you said you were working on getting the recording of the last one. How do I go about getting that? You were working on the recording of the last?
I'm working on figuring out why and to see if we can actually get it down.
Say it again?
I said I'm working on figuring out why.
Why I can't get it?
Yeah.
Okay, so how soon can I get it? Or how soon can I find out your answer?
That's not an answer that I can actually give you because I have to go through different people in order to...
Who will I be hearing from?
You
Or do I need to file another open request at a certain time?
Agreed for. Thank you, Ken.
What I can do is I can email your attorney once I get an answer.
Okay, she doesn't really bring me up on anything, but we can try it that way. I can't even get copies of the records, you know. I've mentioned to many people we can subpoena, she just won't hear any of it.
Well, if you want to wait till next week and try to do another request.
Well, by next week I may be in jail. Mm-hmm.
That's kind of the best answer.
Yeah, but the judge
We
himself.
can contact her.
Yeah, but the judge himself during the trial gave a reason what they didn't do, that they didn't go for the First Amendment, that the square feet wasn't big enough. He told them to tell where they went wrong. But thank you. Well, you plan on getting together anytime soon? We have a lot of ground you can cover.
No, I am not meeting you in your
Like the subpoena and Dr. Reverend Pitt.
I have her under subpoena and I have another individual under subpoena.
She will be here. And what about Mr. Bliss? I mean, they violated green law that the county ignored my
They're not
complaints
on
again.
trial. They're not on trial, and this is a revocation.
Yeah. All right, you have a good day, Mr. Kim.
All right, you too, Dr. Avery. Take care.
Like,